Warm greetings everyone. I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's talk is classification of law. First of all, welcome all to today's talk. Dear friends, after going through today's module, you will be able to understand the concept and meaning of classification of law. Dear learners, the present module is divided into three parts. In the first part of this module, we will discuss the meaning and concept of classification of law. In the second part of this module, we will talk about the purpose of classification of law. In the third part of this module, we will discuss the jurisprudential aspect of the classification of law. This part is further divided into three parts, in which we will discuss Salmon's opinion about classification of law, John Austin's view on classification of law, and Holland's approach about classification of law. So, dear friends, let us begin with the brief overview of the topic. The classification of law is a crucial component within a broader spectrum of legal methods. By categorizing laws based on their nature, scope and application, legal system can provide clarity and coherence. This module explores the various classifications of law, shedding light on how this systematic approach contributes to a more organized and effective legal framework. The world of law is a complex tapestry woven from various threads, each representing a distinct aspect of legal methods. Before delving into the classification of law, it is essential to grasp the foundational concepts. The classification of law is an ancient idea that dates back to ancient times. The original organizers of things were the Roman legal experts. Similarly, the ancient Hindu legal experts created 18 categories or sections for Vivhar, which is about civil law matters. Criminal law is separated from civil law and put into different groups. However, there are two limits to how laws are categorized. Any arrangement is only useful for other things, and there can't be a set of big principles or rules. The old guidelines changed over time in how they worked and the situation they were used. New guidelines based on new ideas also came up, so a new way of organizing is needed. Roman legal experts used to organize laws, but today's world thinks that their way of organizing isn't clear. Laws can be classified in many ways, such as criminal law and civil law, public law and private law, the real rules and the process rules, laws of one country and laws that work across countries, and so on. Dear friends, moving further, now we will discuss the meaning of classification of law. The classification of law refers to a systematic categorization of different legal rules and principles based on their nature, scope, or application. This helps in organizing and understanding the vast body of legal principles and norms. It involves grouping different types of laws to facilitate better understanding, organization, and study of legal system. By classifying laws, legal experts and practitioners can easily identify and differentiate between different aspects of the law, making it more manageable to navigate the complex and diverse field of law regulations. The classification helps in structuring legal education, practice, and research, and it assists in clarifying the relationship between different branches of law and their application in various situations. Overall, the classification of law contributes to a clearer and more organized understanding of legal framework. The classification of law helps in understanding how different aspects of law interact, how they are applied in various contexts, and how legal system can be structured to address various issues and disputes. Dear friends, it is pertinent to know the purpose of classification of law. The purpose of classifying law is to bring order and clarity to the intricate web of legal principles and regulations. By systematically categorizing different types of laws based on their characteristics, nature and scope, the classification process enhances the understanding, interpretation and application of the legal framework. This organization aids legal professionals, scholars and students in comprehending the diverse aspects of law more effectively. The classification of law serves several important purposes, each contributing to the effective functioning of legal system and the fair administration of justice as follows. The first one is organizing legal principles. Classification helps in organizing the vast and complex body of legal principles into manageable categories. This organization makes it easier to study, understand and apply laws systematically. Second one is facilitating legal research and education. By categorizing laws into different classifications, students, legal professionals and researchers can focus on specific areas of law without being overwhelmed by the entire legal system. It streamlines the process of learning and applying legal knowledge. Next one is improving legal practice. Classification aids legal practitioners by providing a framework for identifying relevant laws and precedents. For example, a lawyer specializing in family law will focus on cases and statutes related to family issues, while a criminal defense attorney will focus on criminal law. Further, streamlining judicial processes. Courts and legal systems benefit from classification by having a clear structure to follow when adjudicating cases. The next one is facilitating law reform and development. The classification of law helps lawmakers and legal reformers to identify areas that need updating or improvement. It allows for targeting reforms by highlighting specific legal categories that may require attention. Further, clarifying jurisdiction and authority. Classification helps in describing the jurisdiction and authority of different legal bodies and institutions. For example, it distinguishes between the roles of criminal courts and civil courts as well as between different levels of government in federal system. Promoting public understanding. By classifying laws into recognized categories, the legal system becomes more transparent and accessible to the general public. People can more easily find information about the laws that affect them and understand their rights and responsibilities. Dear friends, moving further, now we will discuss the main part of this module, that is the classification of law. As stated earlier, the term law is used in different senses. It denotes different kinds of rules and principles. The jurists have classified law according to their legal perception. At first, we will discuss Salmon's classification of law. According to Salmon, there are 8 types of laws, which are as under. First one is imperative law. It means a rule that prescribes a general course of action imposed by some authority that enforces it by superior power, either by physical force or any other form of compulsion. He further divided imperative law into 2 categories. Divine law consists of the commands imposed by God upon men, either by threats of punishment or by hope of his blessings. Second one is human law. Human laws are the laws by analogy. It is further divided into 4 kinds. First one is civil law. Imperative law imposed and enforced by the state is called civil law. Dear friends, second one is moral law. Imperative law imposed and enforced by members of society is moral law. Third one is autonomic laws. Those enforced by different institutions or autonomous bodies like universities, airline companies, etc. And fourth one is international law. Those imposed upon the state by Society of States and enforced partly by international option and partly by the threat of war. And last one is physical or scientific law. Physical laws are the law of science that are expression of the uniformities of nature. They are not created by humans and cannot be changed by humans. They are invariable forever. Examples of physical laws are the law of gravity, the law of air pressure, etc. Moving further, natural or moral law. Natural law is based on the principle of right and wrong. It is also called universal or eternal law. Rational law, it embodies the principles of morality and is devoid of any physical compulsion. Many laws of the modern time are founded based on nature. Further, conventional law, it is the body of rules or system of rules agreed upon by persons for their conduct towards each other. For example, international law and rules of a club or cooperative societies, rules of a game or sport are best examples of the conventional laws. Further, customary law. Many customs have been prevalent in the community from time immemorial, even before the states came into existence. They have assumed the force of law over time. For example, under Hindu personal law, a man can't marry his brother's widow. However, if there is any custom which allows the same, then the marriage will be valid. According to Salmond, any rule of action which is observed by men when a custom is firmly established, it is enforced by a state as a law because of its general approval by the people. Practical or technical law. Practical laws are the rules meant for a particular field of human activity. Moving further, international law. It is also known as the law of nations as it applies to states rather than individual. It consists of rules which regulate relation between the states inter se. Next one is civil law. The law enforced by the state is called civil law and it contains sanction behind it. Civil law is territorial as it applies within the territory of one state concerned. Civil law differs from special as the latter applies only in special circumstances. Dear friends, now we will discuss Austin's classification of law. John Austin has classified law into following categories. Divine law. Divine law, according to Austin, refers to laws that are believed to come from a divine or supernatural authority. These laws are based on religious beliefs and moral principles as perceived to be dictated by a deity or deities. From Austin's legal positivist perspective, divine law is distinct from positive law that is created by human institutions. Divine law is not considered positive in the same sense because it is not enacted by a sovereign human authority. Instead, it is seen as deriving its authority from a divine source. Austin's positive approach maintains that the validity of law is based on its source and its conformity to a set of human-made rules rather than its moral or divine content. For Austin, the concept of divine law does not have the same legal authority as positive law because it does not come from a human sovereign. While divine law might be deeply influential in shaping moral and ethical beliefs, Austin would argue that it is not part of the legal system in the positive sense. Instead, it influences the moral behavior of individuals and may impact the law created by human authorities. But it is not itself a form of a positive law. Although divine law is not considered positive law, it can indirectly influence human laws and legal systems. For instance, many legal systems have been historically shaped by religious principles and moral values derived from divine law. But these influences are interpreted and enforced through positive law. For Austin, divine law is an important aspect of moral and ethical discourse, but it is not classified as a positive law. His focus remains on laws that are created and enforced by the sovereign authorities, with divine law seen as separate form of domain of legal positivism. Further, human law. John Austin's perspective on human laws is central to his legal positivism. His theory primarily concerns the nature, authority and classification of human laws as opposed to divine or moral laws. According to Austin, human laws are essentially positive laws which are created by human authorities. Positive laws are commands issued by sovereign authority that are intended to regulate behavior and are enforceable by the state. Austin defines law as a command issued by a sovereign to its subjects. A law is a directive that obliges individuals to act in a certain way or to refrain from certain actions, backed by the possibility of sanctions if the command is not obeyed. Characteristics of human laws. First one is sovereignty. For a law to be considered a positive law, it must come from a recognized sovereign authority. The sovereign is an individual or group with supreme power who can issue commands and enforce them. Austin emphasizes that the legitimacy of law comes from its source in the sovereign rather than its contents or moral values. Further, sanctions. Human laws are associated with sanctions or penalties for non-compliance. Austin argues that the enforcement of law through the threat of sanctions is what distinguishes legal rules from mere moral or ethical guidelines. Third one is obligations. Positive laws create obligation for individuals. These obligations are based on the authority of sovereign and are enforceable through legal mechanism. Further, types of human laws. Imperative laws. These are direct commands issued by sovereign. They include statutes, regulations and administrative orders that are expected to be followed and are backed by penalties for non-compliances. Second one is declaratory laws. These laws declare or elucidate existing legal principles rather than create new ones. They might explain or interpret previous statutes or judicial decisions. John Austin's classification and theory of human laws focus on laws as commands from a sovereign authority that are enforced through sanctions. His legal positivism emphasizes the importance of the source and authority of laws over their moral content or adherence to natural law principles. Further, positive morality. John Austin's concept of positive morality is part of his broader legal positivist theory. Although Austin's primary focus was on legal positivism and the nature of law, he also touched upon the idea of morality, which he distinguished from law. Austin uses the term positive morality to refer to the set of moral beliefs, values and practices that are accepted and observed within a particular society or community. Unlike natural morality, which might be considered universal, moral principles, positive morality is specific to a given society and reflects its unique moral and ethical standards. Austin draws a clear distinction between law and morality. For him, Positive law consists of commands issued by sovereign authority that are enforceable through legal mechanism, whereas positive morality refers to the moral norms and values that people follow based on social or cultural consensus rather than legal obligation. Positive morality comprises norms that guides individual behavior but do not necessarily have the force of law. These norms are shaped by societal values and customs, and while they might influence the content of laws, they are not legally enforceable in the same way that positive laws are. In Austin's framework, positive morality refers to the moral norms and values accepted within a particular society. While positive morality can influence the development and application of law, Austin maintains a clear distinction between moral values and legal rule. His legal positivism focuses on law as a product of human authority and command separate from the realm of morality. At the last but not the least, we will discuss Holland's classification of law. Holland classified laws according to their functions. He classified law into following 5 categories. First one is private and public law. Private law determines the relationship between person and person, whereas public law deals with the relationship between person and the state. In private law, the state is only the enforcing authority, while in public law, the state is an interested and enforcing party. Laws of property, contract, torts, trust, etc. are instances of private law. Examples of public law: the law of crime. Public law is further divided into 2 parts. The first one is constitutional law. Constitutional law includes all rules which directly or indirectly affect the distribution or exercise of the sovereign power of the state. It is the body of those legal principles which determines the constitution of the state. Second one is administrative law. It describes in all detail how the government shall exercise those powers that were outlined in the constitutional law. Further, general and special law. The territorial law of a country is called general law. For example, the Indian Penal Code and the Indian Contract Act are the general laws of the country because they have general application throughout the territory of India. Besides general law, there are certain kinds of special laws. Laws applicable to particular locality like Punjab Police Act, etc. Further, substantive and procedural law. Substantive law is that law which defines a right, while procedural law determines the remedies. Substantive law is concerned with the ends that which administration of justice seeks to achieve, while procedural law deals with how those ends can be achieved. For example, the law of contract, transfer of property, law of crimes, etc. are substantive laws, whereas the Civil Procedure Code or Bharatiya Nagrik Suraksha Sanhita are procedural laws. Moving further, antecedent and remedial law. Antecedent law relates to independent specific enforcement without any resort to any remedial law. For example, the law relating to specific performance of a contract is a best example of antecedent law. The remedial law provides for the remedy. For example, law of torts, writs, etc. come within the category of this law. So, dear learners, I would like to end today's discussion by saying that the different fields of law have been discussed above, which support a legal system all over the globe. Each branch of law plays a vital role in offering order and justice, whether it is constitutional law, which mainly creates governmental boundaries and fundamental principles to common and statutory law. which plays a vital role in describing particular rights and responsibilities. When we talk about civil law, it generally governs property rights and personal affairs, whereas criminal law deals with offences against the society. However, together all these types of law create a unified and solid legal aspect that protects an individual's liberties and also promotes societal harmony. John Austin's definition of law and classification of laws have left an enduring legacy in the field of legal philosophy and jurisprudence. While this definition may not provide a comprehensive account of all aspects of law, it serves as a foundational concept that emphasizes the ethical and societal purpose of law in the administration of justice. This perspective has influenced subsequent legal thought and scholarship. Salmon's classification of laws, on the other hand, offers a systematic framework for understanding the different sources and types of laws, shedding light on the rich tapestry of legal principles that govern various aspects of human life. Salmon's work continues to be studied and discussed by legal scholars and philosophers, as it provides a valuable starting point for exploring the nature of law, the role of the state and relationship between law and justice. His emphasis on the state's recognition and enforcement of legal principles remains a fundamental aspect of modern legal system, and his ideas have had a lasting impact on the field of law. This definition highlights the ethical purpose of law, its role in administration of justice, and essential function of courts in applying and enforcing legal principles. While subject to criticism and debate, Salmon's definition of law has had a profound influence on the understanding and law's nature and significance. So friends, with this we will end today's talk. We will see you in the next module. Thank you so much for patience listening.